DUID defenses will vary based on the circumstances of the case. DUID means driving under the influence of drugs or an intoxicating substance. These cases may involve illegal drugs, prescription medication, medical marijuana, over-the-counter medication, or a combination of substances. A DUID accusation does not automatically mean the state can prove its case. Drug-related driving cases are often more complicated than alcohol DUI cases because drug testing does not always show when a substance was used, how much impairment existed, or whether the person was actually unsafe to drive. Understanding DUID in Oklahoma. In Oklahoma, the state may charge a person with DUID if it claims the person drove, operated, or was in actual physical control of a motor vehicle while under the influence of an intoxicating substance. This can include controlled substances, prescription medication, marijuana, or other substances that allegedly affected the person's ability to drive safely. In many cases, the state must prove more than the mere presence of a substance. The prosecution must connect the substance to the driving conduct and prove the required elements beyond a reasonable doubt. The defense should carefully examine what the officer observed, what the driver did, what testing was performed, and whether the evidence actually shows impairment. Medical marijuana and DUID. Medical marijuana can create complicated DUID issues in Oklahoma. A person may lawfully possess or use medical marijuana under state law and still face a DUID allegation if law enforcement claims the person drove while affected by marijuana. Marijuana cases are especially difficult because THC may remain detectable after the period of actual impairment has passed. A positive test does not always tell the full story. The defense may challenge whether the test result proves impairment at the time of driving, whether the officer had enough evidence to request testing, and whether the state can prove the person was actually under the influence while operating the vehicle. Prescription medication defenses. A DUID charge may also involve prescription medication. Many people take medication exactly as prescribed and do not realize the state may later claim the medication impaired their driving. These cases may involve pain medication, anxiety medication, sleep medication, muscle relaxers, antidepressants, seizure medication, or other prescribed substances. A valid prescription does not automatically defeat a DUID charge, but it may be important evidence. The defense may examine dosage, timing, medical instructions, side effects, tolerance, drug interactions, and whether the accused actually showed signs of impairment. The traffic stop may be challenged. Many DUID cases begin with a traffic stop. The officer may claim the driver crossed a lane line, failed to signal, drove too slowly, made an improper turn, committed a traffic violation, or appeared suspicious. If the stop was not legally justified, the defense may ask the court to suppress evidence gathered after the stop. A weak traffic stop can affect the entire case. Body camera footage, dash camera footage, dispatch records, officer reports, and witness statements may show that the stop was not supported by reasonable suspicion or probable cause. Field sobriety tests are not perfect. Officers often rely on field sobriety tests in DUID cases. These tests may include the horizontal gaze nystagmus test, walk and turn test, one-leg stand test, alphabet test, counting test, or other roadside exercises. The problem is that these tests are not always reliable indicators of drug impairment. Medical conditions, injuries, age, fatigue, nervousness, poor lighting, uneven pavement, bad weather, footwear, traffic conditions, and confusing instructions can affect performance. A person may appear unsteady or nervous for reasons that have nothing to do with drugs. Blood and urine testing issues. DUID cases may involve blood or urine testing. These tests must be handled carefully. The defense may review whether the sample was lawfully obtained, whether consent was valid, whether a warrant was required, whether the chain of custody was preserved, whether the testing lab followed proper procedures, and whether the results actually prove impairment. A test result may show the presence of a substance, but that presence is not always the same as impairment. The timing of the test matters. A person may test positive because of prior use, lawful medication, or a substance that remained in the body after the impairing effects ended. Actual physical control. A person does not always have to be actively driving down the road to face a DUID-related charge. Oklahoma law also recognizes actual physical control. This may arise when a person is found in or near a vehicle, sometimes while parked, asleep, or stopped. Actual physical control cases require careful factual review. The defense may examine whether the vehicle was running, where the keys were located, whether the person intended to drive, whether the vehicle was operable, whether the person was safely parked, and whether the person was actually in control of the vehicle. Lack of impairment. One of the most important DUID defenses is lack of impairment. The state may have evidence that a substance was present, but still fail to prove that the substance impaired the person's ability to drive. Normal driving, clear speech, steady movement, polite cooperation, correct answers, and lack of unsafe conduct may support the defense. Video evidence can be especially important. Dash camera and body camera footage may show whether the accused appeared impaired or whether the officer's report exaggerates the observations. Constitutional DUID defenses. DUID cases may involve constitutional issues. The defense may challenge an unlawful stop, illegal detention, improper search, involuntary statements, invalid consent, lack of probable cause, or improper testing procedures. If evidence was obtained unlawfully, the defense may ask the court to suppress it. Suppressing key evidence can significantly weaken the prosecution's case. If you have been arrested for DUID in Creek County, speak with an experienced Oklahoma criminal defense attorney as soon as possible.